As you'll note that this ruling was prepared under 20 minutes, so you'll have to bear with the chair. Now, as you will recall, at the commencement of the hearing of the proposed removal by impeachment of Dr. Eric Mutai, Governor of Kericho County, earlier today, 14th of October 2024, a number of preliminary issues and questions were raised. Counsel for the County Assembly raised the following two preliminary issues. One, in the first preliminary issue, Counsel indicated that in correspondence that had been issued to the Office of the Clerk, the County Assembly had requested that arrangements be made to secure the anonymity of one of the witnesses who will be testifying for the County Assembly. Counsel reiterated that pursuant to Rule 28, Part 1 of the third schedule to the Senate Standing Orders, the County Assembly sought that the necessary arrangements and facilitation be provided in this regard. On this matter, Counsel for the Governor indicated that the Governor objected to this request. And two, on the second issue, Counsel indicated that on the receipt of documentation filed by the Governor on Sunday, 12th of October 2024, the County Assembly had observed that the Governor proposed to raise a number of preliminary questions. In this regard, the County Assembly had prepared an affidavit dated 13th of October 2024 in response to the preliminary questions, and the County Assembly sought that the affidavit be admitted and be deemed to be properly on record. On this matter, Counsel for the Governor indicated that they had no objection, and consequently, the affidavit was made available to all senators. Counsel for the Governor raised the following three preliminary questions and issues. One, the first preliminary issue related to the documents submitted by the Governor. Counsel stated that the documentation was not properly paginated and sought the indulgence of the Senate to be allowed to withdraw and replace the documentation. Counsel for the County Assembly did not object to this request, and the documentation was subsequently availed to all senators. This matter was therefore dispensed with. In the second preliminary issue, Counsel stated that on the 3rd of October 2024, the High Court at Kericho had issued orders restraining the County Assembly of Kericho, the Speaker of the County Assembly of Kericho, the Senate, and the Speaker of the Senate from considering the impeachment matter. Counsel referred the Senate to the order and specifically cited paragraph 5 of the order, which reads as follows: that pending the inter-parties hearing of the motion dated the 2nd of October 2024, an interim order is hereby issued to restrain the Senate and the Speaker from receiving or acting or presenting to the plenary of the Senate and or allowing for debate at the Senate, at plenary, or at any Senate committee, at or discussing and or making any decision or resolution in regard to the impeachment of the petitioner, Governor, Kericho County Government. Counsel therefore urged the Senate to find that in light of the court order, the matter should not proceed before the Senate. On this matter, Counsel for the County Assembly indicated that the County Assembly objected to this preliminary issue, stating that the matter did not fit within the definition of a preliminary objection, that it was not a pure question of law, but rather a question of fact. Counsel stated that the County Assembly, in its replying affidavit, had provided evidence and would be making submissions to the effect that no such court orders existed. The third preliminary issue related to the matter of whether two-thirds threshold required under Section 33 of the County Governments Act, Cap 265 of the laws of Kenya, and the Kericho County Standing Orders were met. It was the submission of the Counsel for the Governor that the threshold had not been made, as 31 rather than 32 senators voted in favor of the motion for the proposed removal from office by impeachment, had not met as 31 rather than 32 MCAs voted in favor of the motion for the proposed removal from office by impeachment of the Governor of Kericho County. Counsel therefore urged that on this basis alone, the impeachment proceedings could not proceed. Counsel for the County Assembly took a different view on this matter. First, urging that this was not a matter that could be disposed of as a preliminary matter, and that the County Assembly intended to adduce evidence to prove its case on this particular matter. Council therefore urged that it was necessary, therefore, that this matter to be canvassed within the context of the hearing so that the evidence would be presented and tested in cross-examination. A number of senators spoke to these matters in the morning sitting and in this afternoon sitting. Now, honorable senators, ladies and gentlemen, arising from the preliminary issues and having dispensed with those relating to the submission of documentation, the following are the issues that require determination and further guidance. Number one, whether in light of the court order, if any, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County. Two, whether as contended by the governor, the threshold of 2/3 required at the county assembly was not met. And three, whether the request by the county assembly for arrangements to be made to secure the anonymity of one of the witnesses who will be testifying for the county assembly should be allowed. Now, honorable senators, ladies and gentlemen, it is noteworthy that only two of these three issues need to be determined in the first instance, namely whether in light of the court order, if any, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, and secondly, whether as contended by the governor, the threshold of 2/3 required at the county assembly was not met. The third issue on whether the request by the county assembly for arrangement to be made to secure the anonymity of one of the witnesses who will be testifying for the county assembly should not be allowed will depend on the outcome of the first two questions. In respect of the first issue, which is whether in light of the court order, the Senate is able to proceed with the hearing of the proposed removal from office by impeachment of the governor of Kericho County, the Senate has been faced with similar circumstances in the past. On each occasion, the Senate has had to carefully consider two competing constitutional imperatives that arise. On the one hand, Article 2 of the Constitution provides for the supremacy of the Constitution and for the obligation of all persons and all state organs to abide by the Constitution. On the other hand, Article 1 of the Constitution provides that all sovereign power belongs to the people, and this sovereign power is delegated to the various state organs at both national and county level of government. In accordance with the doctrine of separation of powers, each of these organs are required to perform their functions in accordance with the Constitution while observing the principles of comity and respect for jurisdiction as between state organs. In the words of the former Speaker of the National Assembly, the Honorable Kenneth Marende, while delivering a communication in the National Assembly on the 3rd of September 2009, had this to say, and I quote, "Power thus divided presents the absolutism of the executive, the possible anarchy of parliament on the presumption of the judiciary. The operation of the principle of separation of powers both separates the blends powers so that each branch serves as a check and balance on the powers of the other. It ensures the protection of the rule of law and secures the fundamental rights of an individual. The principle of separation of powers has a superficial simplicity, but is in reality inherently complex." In a communication delivered on the 23rd of October 2019, the then Deputy Speaker of the Senate, Senator Professor Kithure Kindiki, had occasion to consider this matter. The matter arose in the context of the proposed removal from office by impeachment of the then governor of Taita Taveta County. The senator for Taita Taveta County, then Senator Maruma, rose on a point of order and sought the directions of the Deputy Speaker on whether it was in order for the Senate to continue deliberating on a motion and taking further action while there was active proceedings in the matter. In the course of communication, the Deputy Speaker explained why an injunction of Parliament was untenable. The Deputy Speaker stated as follows, and I quote, "Firstly, an injunction by the court against Parliament is a frontal and deadly attack on the substrum and hallowed legal doctrine of separation of powers, the bedrock of our Constitution. Separation of powers creates separate and distinct arms of government with equal but different powers. Each arm must exercise its powers in a fine balancing act to ensure that it carries out its functions without infringing on the powers of another branch of government. Secondly, curtailing Parliament's constitutional responsibilities undermines the sui generis nature of Parliament. Members of Parliament are direct representatives of the people, and thus Parliament cannot be prevented from giving a voice to the will of the people of Kenya. There are checks and balances within the separation of powers, such that while Parliament should fulfill its responsibilities unabated, the courts will have their say in the exercise of judicial authority to declare any legislation or other output of Parliament illegal, unlawful, or unconstitutional. And thirdly, attempts to injunct Parliament are inimical to the desired levels of institutional comity and cordial relations among the branches of government. Intergovernmental relations survive on interinstitutional respect and difference in a mutual manner on the basis of reciprocity. Parliament ought to respect the judiciary, and the opposite is also true. Now, honorable senators, ladies and gentlemen, the Supreme Court and the petition number 32 of 2014, that is Justice Kericho Mutai and another versus Martin Nyaga Wambora and another, 2017, also had an occasion to consider the competing constitutional imperatives and Articles 1 and 2 of the Constitution in what will be described in legal parlance as the locus classicus on this particular matter. In this matter, therefore, the Senate had resolved to remove the then governor of Embu County, Governor Martin Wambora, from office by impeachment. Additionally, the High Court had issued conservatory orders, the effect of which were to prevent the impeachment of the governor. Following his impeachment, the governor challenged the impeachment by an application before the High Court and sought interim orders for his reinstatement into office and an order of contempt of court against the appellants, that is the Speaker and Clerk of the County Assembly of Embu, for allowing an impeachment motion to be discussed, passed while a conservatory order was in place. The governor was successful in his application. The court held that all proceedings conducted in disobedience of the court orders were null and void, and found the appellants guilty of contempt. Aggrieved by this decision, the appellants filed an appeal at the Court of Appeal challenging the findings of the High Court. The Court of Appeal affirmed the findings of the High Court, leading to the appeal to the Supreme Court. Before the Supreme Court, the appellants asked that the trial court ought to have noted the legitimate dilemma facing the Speaker of the County Assembly, who was subject to constitutional timelines, yet was faced with a court order stopping the process. It was urged and argued that in this case, that the Speaker had complied with the Constitution in the context in which the question of constitutional obligation on the one hand and the burden of knowledge of the court order on the other were at stake, and asked the court to clarify to what extent parties would be in violation of legal requirements if court orders that conflicted with constitutional deadlines were binding on them. In rendering its decision, the Supreme Court made reference to the decision of the Court of Appeal in the case of Mumo Matemo versus Trusted Society of Human Rights Alliance and two others, Civil Appeal number 290 of 2012, where the Court of Appeal adopted the High Court's position on the doctrine of separation of powers to this effect. I quote, separation of powers must mean that the courts must show a deference to the independence of the legislature as an important institution in the maintenance of our constitutional democracy, as well as accord the executive sufficient latitude to implement legislative intent. Yet, as the respondent also concede, the courts have an interruptive role, including the last word in determining the constitutionality of all government actions. The Supreme Court further made reference to its decision in the Speaker of the Senate and another versus Attorney General and four others, reference number 2 of 2013, and noted that the court had cautioned against interference with running processes in other arms of government, and had this to say, and I quote, "This court will not question each and every procedural infraction that may occur in either of the houses of Parliament. The court cannot supervise the workings of Parliament. The institutional committee between the three arms of government must not be endangered by the unwarranted intrusion into the workings of one arm by the other." The Supreme Court aptly summarized the principles applicable to separation of powers in Kenya context as follows. that each arm of government has an obligation to recognize the independence of other arms of government. 2, each arm of government is under duty to refrain from directing another arm on how to exercise its mandate. 3, the courts of law are the proper judge of compliance with constitutional edict for all public agencies, but in exercising their judgment, courts should be objective. And 4, for the due functioning of constitutional governance, the courts are to be guided by restraint, limiting themselves to intervention in requisite instances upon appreciating the prevailing circumstances and the objective needs and public interests attending to each case. And lastly, in the performance of the respective functions, every arm of government is subject to the law. In the end, the Supreme Court upheld County Speaker Justice Kericho Mate's appeal and nullified the conservatory orders that had been issued in this matter. In a more recent Court of Appeal case, that is civil application number E093 of 2023, the Honorable Kawira Mwangaza versus County Assembly of Meru and others, the Court of Appeal also considered the issue of whether a court has jurisdiction to intervene in an impeachment process that is provided for in the Constitution and which has strict timelines for determination. In its ruling, delivered on the 27th of October 2023, the Court of Appeal, while relying on the decision of the Supreme Court in the Embu impeachment matter, held as follows: that the courts cannot, in the first instance, intervene in the impeachment of the applicant. This is because of the strict timelines provided by the law. The Supreme Court decision of Justice Kericho Mate is binding on this court. The preliminary objection is therefore upheld. This court lacks jurisdiction in the first instance to consider the merits of the applicant's application, which sought conservatory orders before the impeachment process has run its constitutional and legal course. Now, honorable senators, ladies and gentlemen, I note that the constitutional mandate to impeach a governor is assigned to the County Assembly and the Senate. Article 181 of the Constitution provides the circumstances under which a governor may be removed from office. In line with the terms of Article 181(2) of the Constitution, Parliament duly enacted the County Governments Act, Cap 265, which at Section 33 sets out the procedure to be followed in the proceedings for the proposed removal of a governor. Further, Standing Order 8 of the Senate Standing Orders also provides for the procedure for removal of a governor from office. These provisions provide for strict timelines to be followed by the Senate in such proceedings. Honorable Senators, constitutional and statutory timelines cannot be wished away by the issuance of ex parte orders, as this will jeopardize the Senate's constitutional and statutory obligations. Professor Kithure Kindiki, the then Deputy Speaker in the Senate, could not have put it in a better way in a ruling that he delivered on the 23rd of October 2019, when he ruled, and I quote, "I respectively but firmly determine that beyond peradventure, courts of law cannot and shall not stop or attempt to prevent Parliament from undertaking its constitutional mandate. Neither can the judiciary compel any action to be undertaken by Parliament. I rule any injunction interfering with the work of Parliament has no effect on Parliament in exercise of its constitutional functions. Such court orders have no effect on the National Assembly or the Senate or any of their committees, respectively. In the unlikely event of any such orders, Parliament and its committees shall proceed unabated, unfettered and unhindered, as may be directed by the respective Speaker of Parliament." Now, the question of the effect, if any, of the court orders injuncting the Senate from conducting any business is well settled. In this respect, the determination on the question is the same regardless of the position advanced by the County Assembly. Whether or not there was, in fact, a court order in this matter does not matter. Nothing turns on it. The result is the same, which is that Parliament cannot be prevented from the discharge of its constitutional functions by dint of an order of the court. The second issue then is the second issue for determination then is whether, as contended by the governor, the threshold of 2/3 required at the County Assembly was not met. Related to this question is whether this is a question of fact, necessitating evidence to be adduced by the county, as contended by the County Assembly, or a pure question of law requiring to be determined before the proceedings can continue? In other words, is this a classical preliminary objection or not? This question is important because in virtually all impeachment proceedings before the Senate, preliminary objections have been raised, and in no instance has the Senate terminated proceedings on the basis of a preliminary objection. Successive speakers have ruled that a preliminary objection would be considered together with the evidence and determined on the merits of the matter. In truth, the findings have meant that the preliminary objection raised did not fit within the true character of a preliminary objection. Now, a preliminary objection was defined in the case of Mukisa Biscuit Manufacturing Company Limited versus West End Distributors 1969 EA 696 as follows. A preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings and which is argued as a preliminary point and which, if argued as a preliminary point, may dispose of the suit. A preliminary objection raises a pure point of law which is argued on assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has not been ascertained or if what is sought is the exercise of a judicial discretion. In this case, it is not in contention that the County Assembly of Kericho has 47 members, and that one of these members voted in favor of the motion for the proposed removal from office by impeachment of the governor of Kericho County. The only question that has arisen as a preliminary matter is whether the 2/3 threshold was met and the consequence if such threshold was not met. Linked to this question, it is the question whether this is a matter to be determined by the Speaker under Rule 30 of Part 1 of the third schedule to the Senate Standing Orders, or a matter to be determined by plenary. This matter was argued by counsel for the governor in support over determination by the Speaker, while the County Assembly took the opposite view. Senators who spoke supported the view advanced by the County Assembly. It is not in doubt that the trial court in impeachment matters is the Senate. It is, however, also not in doubt that Rule 30 vests in the Speaker as the presiding officer the power to make certain determination for purpose of continuity of proceedings, of impeachment proceedings. Nevertheless, taking one thing with another, and in the context of the totality of the current proceedings, I rule that the question on whether to uphold the preliminary objection raised by the counsel for the governor on the matter of whether the threshold for impeachment was met will be determined in the present case by a vote of the Senate. This is so because, as earlier explained in this ruling, the preliminary objection raised in the present case is of such momentous character that it goes to the substratum of the impeachment proceedings and has the prospect of terminating the proceedings at this point. The County Governments Act and the Senate Standing Orders did not contemplate a situation where the Speaker is called upon to terminate the proceedings in a proposed impeachment without the participation in that decision by the Senate. I further rule that considering that the effect of this vote could be a determination of the impeachment process as a whole, this is a matter concerning counties, and accordingly, the preliminary objection will be upheld if supported by 24 delegations. In such event, the present proceedings will forthwith terminate. The procedure for going to this vote, honorable senators, will be motion in the usual manner, preceded by a notice of motion. The vote will be taken upon the conclusion of debate in the usual manner, and to this end, I have directed the clerk to prepare and circulate a supplementary order paper containing the notice of motion and the motion as soon as I conclude with this ruling. One further matter from the preliminary issues raised remains outstanding, which is the matter of the request made by the County Assembly for the protection of the witness. This question will only become relevant after the disposal of the motion. It is so directed.